The Second Amendment case going to SCOTUS relates to the difficulty that is involved in getting a concealed carry in the state of New York. Difficult to the point of virtual impossibility, where you have to show actual need for this type of potential self-defense, and apparently the threshold is so high that it's basically outlawed altogether. Yes. I don't know the history of the Second Amendment cases. I know Heller was the big one. I think I have an idea of what Heller was, but do you want to give us the historical context and then the specifics of this case and what you expect to occur?
Well, I mean, it's big because the Ninth Circuit affirmed Hawaii not allowing any conceal and carry. So it's in that context that they took it. So basically it's do your gun rights only apply inside your own home? Because that makes no sense to me. It's a right of self-defense, and it's the means of self-defense is the right to bear arms. But but the core interest it's protecting is the right of the individual to defend themselves against the state or anyone else. And that's what it's all about. In my view, it's a Second Amendment is a constitutional right to self-defense. Supreme Court said that effectively in Heller, said it similarly in McDonald. And in that context, I'm glad they finally took a case because they were skipping a lot of good cases. And people were getting concerned that the latest attack on the Second Amendment is to try to limit it to say, okay, you have a right to defend yourself and bear arms, but only inside your own home, nowhere else. You can't carry it with you anywhere to defend yourself outside of your own home. And that would effectively gut half of the Second Amendment. Because, I mean, more often than not, you need to defend yourself outside of your home. It's not just inside of your home.
And am I wrong? In one of the courts had actually equated the militia to a state militia, not an independent militia, like where they said that every state
had 100. I mean, the militia part, it does not limit the rest. The militia was simply a means and mechanism to protect, to enforce that right against the state in part. And so the attempts to use that to limit the rest of it is just not what the Second Amendment was about. Second Amendment was always about a right of self-defense by which the most effective means was bearing arms. And the militia component, in my view, is a separate component, not a limiting component. And it's as a bunch of courts have tried to come up with every pretext known to man so the state can deny you and deprive you of your means to defend yourself, including against the state if necessary. And so that's what it's about. And to me, that means the fact they took it, very, very strong sign. They're going to say the Second Amendment applies to a right of self-defense anywhere, anyplace, anytime. And so the restrictions on that have to conform with the Heller provisions, that the right to defend yourself is not limited to your home. And that's what that case means. And that's why it's very heartwarming for those of us who are Second Amendment purists that they took this case, because that's where they were attacking it in so many different jurisdictions across the country. And everybody kind of knows once they took it, given the current nature of the court, that it's highly likely the Supreme Court is going to step in and say that, in fact, because here's why. They wouldn't have got 4 votes to take it unless they were going to say, yes, Heller, the Second Amendment applies to a right to self-defense, including to bear arms outside of the home. It's a right across the board. And that's what New York law was more explicitly rejecting. New York was saying a right of self-defense does not give you the right to carry a gun outside of your home. In fact, concealing carries are so difficult in New York, it made part of a Billions episode, multiple Billions episodes about somebody using their political corruption just to be able to carry a gun with them. So it's long been a basis by which and I think it will. I think they'll expand it, extend it, and it will change conceal and carry laws across the country.
Okay, it's interesting. My initial reflex was that they were going to take it to gut it, not to reaffirm the right. But that might be.
I don't think they wouldn't have got 4 justices to sign on, because the justices would have not interfered or intervened that don't want to expand gun rights. They wouldn't have voted to take the case. So the fact that there were 4 votes, in my view, means that they likely have the 5 votes to reverse. And while I've been a critic of Barrett in the gun context, she has shown signs of being a purist. So on the Second Amendment, I think she'll be a good vote. No doubt Alito, Thomas, and Gorsuch will. So that only leaves, Kavanaugh and Roberts as swing votes. But I think that my guess is Kavanaugh will go the Second Amendment route as well, because I don't think the other 4 would have voted to take it if they didn't think they already had a 5th vote to rule their way.
Okay, that's interesting. I definitely don't have the depth of understanding of it that you do. I'm just more cynical and saying, the way things are going, they're going to take it and say, no, you have a right to self-defense in your home, castle doctrine only, and that doesn't apply outside of your home. So go satisfy the stringent burden to explain why you need a concealed carry to defend yourself against imminent threats in public, and we'll grant you one, and that means never granting them. What timeline on this? Like, how does it work?
So they've taken it, and then there'll be merits briefs and then oral argument. The decision may issue within the year, maybe next year. Sometimes it goes over, but we would anticipate a decision by summer in all likelihood.
Okay, very interesting. Which brings us into the second facet of this discussion. Explain what's going on. Do they want to allow gun manufacturers to be held liable for crimes committed with weapons out of New York?
Period. Basically, that's it. They want to drive gun manufacturers out of business.
Is this New York or is this
state of New York?
Okay.
So, basically, they want to make them expand their liability so broadly. The one case that's trying to do it is the Sandy Hook cases against the gun manufacturers there, where the U.S. Supreme Court passed on taking because there's a federal law that currently precludes this from happening. And so it's really, they're challenging a federal law that's on the books by doing so. But yes, basically they want to make it so that no sane gun manufacturer would manufacture a gun that could be sold in the state of New York because you could get sued into oblivion in the wrong political jurisdiction. That's what the New York state law they're trying to pass is.
I think I understand something about the federal law, and I think it was one of the issues that some people had with Bernie Sanders is that he supported the law to give immunity. Why? Explain some of it.
Because gun manufacturers were going to quit manufacturing guns. If they could be sued for any use of their gun, then they were going to quit manufacturing guns. Because they would be bankrupted in the wrong political jurisdiction. And so that's why the Fed stepped in and said, no, we want to make sure you continue to make guns here in the United States and protect gun manufacturers, because we have some certain safety controls and other controls over that. And so we're not going to allow cities and states to pass these kind of laws or apply their existing laws to achieve that objective. And that's why the law is there. Now, the Supreme Court chose not to enforce it in the Sandy Hook case, though they could always enforce it later. So they just passed on the first pass of it. But I think this case is going to be a seminal case and more consequential ultimately than Heller, because it will expand the Second Amendment right of self-defense in general. Even though they didn't take my petition that I drafted for Michael Strickland, is the argument that I'd made was get these kind of arguments in front of the court, because they may take another case, but you're making the policy argument as to why they need to take such a case. And to make clear, the argument in Strickland was more pure. It was say the Second Amendment protects self-defense, period. But this decision can achieve the same objective if they do so.
Okay, but if you just get back to the history of the federal law of giving immunity to gun manufacturers, I would imagine that somewhere down the line, even if you had the various lawsuits in various jurisdictions, it would work its way up to the Supreme Court, where they would say, no, you can't go after the manufacturers of someone who used something properly. I say properly in the sense that it functioned as the product was intended to function, just with the wrong purpose. Much in the same way, driving a car into somebody, the car will function the way it was intended to be created. But if it's used for criminal purposes, the car manufacturer is not responsible for the criminal use of a product designed and that functions properly. So right. I would imagine it would get to a higher court, the highest court, and they would set that precedent so that you wouldn't have to worry about this. Why did they go by way of a federal law as opposed to allowing it just to work its way up and be resolved judicially by the highest court?
Well, because the fear was that state governments would pass their own laws, that without that federal law, you would be able to basically ban gun manufacturing in the United States by making them subject to easy liability. So the federal law was needed to preempt the ability of state governments to impose their own set of laws and rules that could effectively bankrupt gun manufacturers. So that's why it exists. Now, the state of New York may be assuming that either the courts won't enforce that law because of what they saw has happened to date in the Sandy Hook gun cases, or because they are anticipating changing that federal law, or they're believing that such federal law will change such that then the law will become enforceable. So that may be their objective, but it shows clearly what their objective is. If you're banning the manufacturing or sale of guns indirectly by bankrupting anybody through lawfare that actually manufactures and sells guns, haven't you effectively achieved the same objective of banning guns without having to do so directly?
My obvious logical concern would be, does someone who supports that idea, because they would want that, not appreciate the consequences of that? It would.
It's their goal. That's what they want to do.
Well, but it's not a reductio ad absurdum. It's just the reality is you would have car vehicles being vehicle manufacturers being sued. Manufacturers.
Yes, I agree that concept was applied across all industries, but they're only applying this to gun manufacturers.